Ladies and gentlemen, respected participants, and to our esteemed professor, good day and welcome everyone as we witness the power of discourse and the art of persuasion, where intellect meets eloquence in the arena of ideas. I am Mark Gabriel Palmares.
And I'm Larry Stison, and we are your hosts for this debate.
And it is our privilege to stand before you as we embark on an intellectual journey.
That promises to be both enlightening and thought provoking. Our distinguished debaters are prepared to engage in a battle of words, armed with compelling arguments and a commitment to articulate their perspectives with clarity and conviction.
The topic at hand is intellectual property piracy, from which stems an ethical dilemma of individuals arguing for free access to information, citing economic disparities, and the high cost of software. On the other hand, creators and companies argue that piracy undermines innovation and jeopardizes the livelihood of those who invest time and resources in producing quality content.
As we delve into the discourse, let us remember the value of open mindedness and the willingness to listen. For it is through this exchange that we, as a collective, can broaden our perspectives and deepen our understanding. It is in this spirit that we convene today, fostering an environment where ideas clash, not with hostility but with the intent to illuminate the truth.
Before we proceed, let us express our gratitude to the Virtus Byte Squad and our Professor Gerard G. Ravasco for making this event possible. Their commitment to intellectual dialogue has brought us together today, and we extend our appreciation for their support.
So without further ado, let the debate begin. May the ideas flow freely, the arguments be robust, and may we all leave here today with a greater appreciation for the power of civil discourse.
Now, let's hear it from the Prime Minister of the opening government, Michael Episcope.
Ladies and gentlemen, I stand before you today as the Prime Minister of the opening government to address the pressing issue of intellectual property piracy's ethical dilemma. Intellectual property piracy poses a significant challenge to the principles of creativity, innovation, and economic fairness. I rise as the Prime Minister to assert the critical importance of intellectual property protection in our digital age. Individuals argue for free access to information, citing economic disparities and the high cost of software. On the other hand, creators and companies argue that piracy undermines innovation and jeopardizes the livelihood of those who invest time and resources in producing quality content. The ethical dilemma we face is indeed a complex one, but the impact of piracy on innovation and livelihood is undeniable. Hence, to avoid committing intellectual property piracy, it is recommended to use open source software. As stipulated in Red Hat's report in 2022, organizations' adoption of open source software or software that can be modified and used publicly marked 21% for community based and 29% for enterprise. These values are expected to increase to 24 and 34% respectively by next year. Information sharing in the form of software not only benefits organizations in terms of security and reliability, but the influence and impact that contributors make proves to be effective and valuable in helping organizations' transformation and sustainability. Intellectual property rights are the foundation of creativity, incentivizing creators to invest time and resources into producing quality content. These rights protect not only multinational corporations, but also small businesses and individual creators who depend on fair compensation for their work. Piracy undermines these incentives, leading to a decline in innovation and the economic livelihood of those who drive our culture and knowledge forward. We must balance the rights of creators with the need for widespread access to knowledge. It is in this spirit that we propose the motion that the government should take a more active stance in combating intellectual property piracy.
Thank you to the Prime Minister for that speech, and now we invite the Leader of the Opposition, Jerome Bartolaba.
Ladies and gentlemen, we, the opposition, recognize the importance of intellectual property rights, but I, the leader of the opposition, firmly believe that the motion fails to consider the intended consequences of aggressive government approach. It risks stifling the sharing of knowledge, innovation, and creativity. As cited in the study of Bhattacharya in 2017, developing countries were always under the economic burden of expensive technological tools and training costs. Evidence shows that the cost of software and information can be a barrier to educational and economic opportunities, particularly for marginalized communities. Yes, I agree that the existence of open source software and tools are helpful, especially in marginalized communities. However, there is always a problem with the software's sustainability. Since it is an open source, the lack of support for software updates limits its use and adaptability to be compatible with new releases, plugins, add-ins, or platforms. In this regard, it deprives societies, especially in developing countries, of the benefits of access to vital information, cultural work, and life-saving technologies. Access to information is a fundamental human right, and we must consider economic disparities and the high cost of software. The ethical dilemma here is whether government intervention is the most appropriate solution. We argue that it may lead to excessive regulation, hinder technological progress, and compromise individuals' rights to access information. We must prioritize a balance between protecting intellectual property and ensuring the free exchange of knowledge. The opposition contends that an aggressive government stance on intellectual property may have unintended consequences, particularly affecting access to vital information in developing countries and creating barriers to educational and economic opportunities. The ethical dilemma at hand requires a delicate approach that balances protecting intellectual property with ensuring the free exchange of knowledge. I will now give the floor back to hear the perspective of the government on this crucial matter.
Thank you to the leader of the opposition for that speech. And now we invite the Deputy Prime Minister, Glenda Heruel.
Ladies and gentlemen, and distinguished members of the House, I, the Deputy Prime Minister of the government, stand firmly in support of intellectual property protection. Intellectual property piracy is an authorized use or reproduction of creators' copyrighted, patented, and trademarked works. IP piracy has a negative impact on the economy as it reduces the incentives for innovation, discourages investments, lowers tax revenues, harms consumers, and undermines the rule of law. I would like to emphasize that intellectual property piracy is not a victimless crime. It undermines the hard work and innovation of creators, discouraging them from contributing to society. Creating content requires dedication, time, effort, and resources. When it is pirated, it devalues their work and makes it challenging to sustain their creative endeavors. While we acknowledge the importance of equitable access to information, we cannot ignore the evidence that demonstrates the significant negative impact of piracy on creators, businesses, and innovation. As such, according to Sharma 2023, online TV and movie revenue lost through piracy in 2016 and 2022 in the United States is more than 11 billion US dollars. Another study by the US Chamber of Commerce found that digital piracy of movies and TV shows costs the US economy at least 29.2 billion US dollars in lost revenue in 2018 and resulted in the loss of 230,000 jobs and 47.5 billion US dollars in GDP. The study also revealed that 26.6 billion illegal views and downloads of US content occurred in 2017, with China, Russia, Brazil, India, and Indonesia being the top 5 sources of piracy. As cited in a Forbes 2023 September report, the US Patent and Trademark Office said that, as of 2018, the sales of counterfeit and pirated goods totaled between $1.7 trillion and $4.5 trillion annually. IP piracy also affects developing countries such as Nigeria, where IP violations hinder economic growth by discouraging research, diminishing financial benefits from creation, and posing harm to consumers. For example, counterfeit medicines, which account for 70% of the drugs sold in Nigeria, pose serious health risks and undermine the trust in the healthcare system. Additionally, in a report prepared for the International Chamber of Commerce, the global value of counterfeit and pirated products was estimated to be $1.77 trillion in 2015, which is equivalent to 2.3% of the world GDP. The report also projected that by 2022, the global economic and social costs of IP piracy could reach $4.2 trillion and put 5.4 million legitimate jobs at risk. Therefore, IP piracy is a serious threat to the global economy and society and requires coordinated efforts from the governments, businesses, and consumers to combat it. Our argument is evidence-based, drawing upon numerous studies demonstrating the negative effects of piracy on innovation and creative industries. Let us acknowledge the evidence and stand in support of innovation and the protection of intellectual property, as it is essential for fostering innovation, creating jobs, enhancing competitiveness, and ensuring consumer safety. And with this, I end my speech.
Thank you to the Deputy Prime Minister for that speech, and now we invite the Deputy Leader of the Opposition, Rogiel Montañez.
Ladies and gentlemen, as the Deputy Leader of the Opposition, I appreciate the Deputy Prime Minister's acknowledgement of the importance of equitable access to information. However, we must not disregard the evidence that excessive copyright enforcement can have killing effects on innovation, hinder competition, and limit access to knowledge, particularly for those who cannot afford costly software or content. Research indicates that some industries have thrived by adopting more flexible approaches such as subscription models and premium services. Policies should focus on fostering innovation, accessibility, and affordability, ensuring that our approach is both ethical and effective. To address this ethical dilemma, it is crucial to highlight that the burden should not fall entirely on the government. We, in the opposition, believe in strengthening private sector's initiative, market-driven solution, and international cooperation. Rather than imposing government control, we should encourage innovation in combating piracy while safeguarding individual freedom and access to knowledge.
Thank you to the Deputy Leader of the Opposition for that speech. And now we invite the government member, Vincent Luage.
As a member of the government, I would like to address the concerns raised by the opposition. We understand the importance of a balanced approach. The motion does not suggest that government intervention should be the sole solution. It emphasizes the need for a proactive role by the governments in international forums and partnerships to create a framework for fair and equitable solutions that benefit both creators and society as a whole. But the software industry and other high-tech based innovation firms, along with entrepreneurs and investors, have deep concerns regarding the protection of intellectual property and trade secrets as their livelihood depends on it. When it comes to choosing where to locate or grow, businesses heavily consider the existence of the system of rigorous and enforceable intellectual property rights. Due to inadequate intellectual property protection offered by the foreign nations like China, numerous companies have discontinued their research and development operations there. Also, online piracy and unauthorized sharing of copyrighted materials have become rampant, with websites and platforms facilitating the illicit distribution of music, movies, software, and other creative works. An often cited estimate from 2007 by the Institute for Policy Innovation says that music piracy cost the US economy more than $12 billion annually. I emphasize that striking the right balance is crucial in this ethical dilemma. Evidence-based studies suggest that piracy has far-reaching negative consequences as stipulated by the government's Deputy Prime Minister's speech, impacting not only creators and companies, but also our consumers. The negative impacts of piracy are not only limited to the aforementioned effects, but according to Mora, pirated contents like software or movies can often be ridden with malware and security vulnerabilities. exposing users to cyber threats. Moreover, one's identity may be stolen if the pirate site asks for personal details. Or worse, since piracy is illegal, if one got caught, he or she could face criminal charges for sharing copyrighted content. The aforementioned evidence underscores the need for strong intellectual property protection, ensuring that consumers have access to safe and reliable products. To end my speech, let us continue protecting intellectual property while ensuring consumers' safety and security. Thank you.
Thank you to the government member for that speech, and now we invite the opposition member, Mike Vincent Montabon.
Thank you, Mr. Speaker. Ladies and gentlemen, as an opposition member, I appreciate the government's concern for consumer safety. However, the members of the government fail to acknowledge the potential harm that government intervention can cause. Evidence suggests that copyright enforcement can be excessive and lead to abuses, such as copyright trolling.
DOI, clarify your claim about copyright trolling and give us evidence to support this claim.
Yes, Deputy Prime Minister. Critics argue that copyright trolling can lead to abuse of legal system, as some copyright trolls may pursue cases of flimsy evidence and their main motivation is to extract money from defendants rather than protect their copyrights. Courts have sometimes critical to these practices, and there have been efforts to curb copyright trolling in various jurisdictions by imposing stricter requirements for bringing copyright infringement lawsuits. According to Capello in 2018, copyright trolling is the practice of exploiting copyright laws to generate revenue through legal threats or lawsuits against individuals or entities, often without a genuine interest in protecting intellectual property rights. It typically involves sending cease and desist letter or filing lawsuits, allege copyright infringer in the hope of obtaining settlement or monetary damages. The copyright troll may be an individual, a company, a law firm that acquires copyright to various works, such as movies, music, or software, with the primary purpose of monetizing those copyright through legal action. They often cast wide net, sending out mass demands for settlements to many alleged infringers, and some of these claims may lack merit. These trolls may use various tactics to identify potential infringers, including monitoring file sharing networks, tracking IP addresses, or using automated tools to detect unauthorized distribution of copyright material. Once an alleged infringer is identified, the copyright troll sends legal threats demanding a settlement payment to avoid a lawsuit. As cited in the report of Bailey in 2018, example of notorious copyright trolls are as follows. Prendalo, a law firm that created shell companies and fake identities to sue thousands of people for downloading pornographic films. Righthaven, a company that acquired the rights to sue online articles from newspaper and sued hundreds of bloggers and websites for reposting them. Getty Images, a stock photo agency that aggressively pursued individuals and businesses for using their images without permission or payment. In other words, it is a form of legal extortion where a party threatens to sue someone for allegedly infringing their copyright, hoping that they will settle out of court. We, the opposition, understand the importance of intellectual property protection, but excessive enforcement of copyright that leads to abuse must be stopped. We must be innovative in our approach and ensure the ethical considerations are grounded in evidence. Intellectual property piracy is a complex issue, and we should focus on fostering collaboration between private entities, not government intervention.
Thank you to the opposition member for that speech. And now we invite the government member of the opposition, Sheila Remonta.
In response to the opposition member's argument, we must emphasize that this motion does not advocate for excessive government control but encourage responsible governance and international collaboration. The ethical dilemma of intellectual property piracy requires a multifaceted approach, and the government should play a pivotal role in facilitating dialogue, not stifling innovation. I stand as a member of government from the opposition, and I stress that our stance is based on the evidence and ethics. While we recognize the need to address economic disparities and promote equitable access to information, evidence shows that strong intellectual property rights can coexist with these goals. Every nation has its own defined laws and strategies for intellectual property protection that should guide our actions, fostering innovation, economic fairness, and the responsible sharing of knowledge. According to Morrow 2023, the penalties for copyright infringement differs from one country to another. In the USA, the penalty includes imprisonment of up to 5 years and fines. Courts may order the defendant to pay the plaintiff attorney fees and costs associated with bringing an action against them. In Russia, the penalty costs from 10,000 Russian ruble up to 5 million ruble. China, on the other hand, requires a full compensation based on the monetary losses suffered, profit occurred during the infringement period, and statutory compensation. Here in the Philippines, it is stipulated in RA number 8293, Intellectual Property Code of the Philippines. Section 217, titled Criminal Penalties, specifically 217.1, states that any person enriching any right secured by provisions of Part 4 of this Act or aiding or abetting such infringement shall be guilty of a crime punishable by imprisonment of 1 year to 3 years plus a fine ranging from 50,000 pesos to 150,000 for the first offense, imprisonment of 3 years and 1 day to 6 years plus a fine ranging from 150,000 pesos to 500,000 pesos for the second offense, imprisonment of 6 years and 1 day to 9 years plus a fine ranging from 500,000 pesos to 1,500,000 for the third and subsequent offenses. In all cases, subsidiary imprisonment in case of insolvency. Copyright enforcement, when proportionate and targeted, can protect creators and companies without infringing upon individuals' rights. Hence, it is noteworthy to point out that we encourage responsible governance and international collaboration by respecting intellectual property through adherence to the law while protecting the creator's right and ensuring that the public can access and use knowledge and creative work legally as it is intended.
Thank you to the government member of the opposition for that speech, and now we invite the opposition member of the government, Mark Gabriel Palmares.
Ladies and gentlemen, we acknowledge the concerns raised by the opposition, but we firmly believe that a more proactive government approach in international forums is essential to address the ethical dilemma of intellectual property piracy. I, as an opposition member of the government, agree with our colleagues from the opposition benches that evidence-based policies should guide our approach. Furthermore, in order to address the ethical dilemma effectively, the implementation of neoteric models, systems, and technologies to protect intellectual property while enhancing transparency and access is another form of solution for us to delve more, as the intellectual property system strives to keep up with the current rate of technological progress and contend with the change in the nature of technology. New technologies may necessitate fundamentally new incentives and raise fundamentally new difficulties for the intellectual property system. The nature of the protection to be provided against program behavior is hotly debated. And given the extent to which computer and communication software is growing in market size and economic value in comparison to the corresponding hardware, the nature of the protection to be provided is essential economically. Since the ease of reproducibility is the first unique feature of software, it may be copied cheaply and transformed relatively readily from one computer language to another. This precisely provides an appeal to the copyright approach to software protection. And few would argue that copying or direct translation should be disallowed in general, for the reason that it fundamentally alters the incentives required to build software in the first place. This field began with an early expert advisory study by the National Commission on New Technological Use of Copyrighted Works, or CON2, which delivered its final report in 1978 and advised usage of the copyright pattern without providing any thorough examination of the implications. CON2 went on to define the technical adaptation to copyright law required to encompass computer programs, such as allowing the copying of a program into computer memory as an essential part of the program's use. Congress followed the CON2 recommendations in amending the Copyright Act in 1980 to define computer programs and to authorize such copies. An example of technology is blockchain. Study shows that the blockchain provides an immutable ledger of timestamped events, where the creators can publish content onto the blockchain and can reach their audience without third parties. The content gets stored on a peer-to-peer network versus a single, siloed server, thanks to the distributed nature of a blockchain database. As a result, fraudsters have one less attack vector, and distributors can publish content directly to their fans. Furthermore, blockchain-based content can create digital fingerprints or watermarks that detect content leakage and identify copies of digital content. Additionally, tokenizing content on the blockchain as non-fungible tokens, or known as NFTs, provides an extra layer of security to prevent illegal content duplication. Evidence suggests that these innovative solutions can create a win-win scenario, protecting creators and promoting equitable access to information. We urge you to support the motion for a more balanced, ethical, and equitable solution. We must remain open to evidence-based strategies that strike a balance between competing interests. And now, we invite the opposition whip, Larise Gison.
Thank you, Speaker. In closing, we believe that the government's approach is misguided. It risks infringing on individual rights to free access to content, and we urge you to vote against this motion. As the opposition whip, I reiterate that our stance is grounded in evidence. We do not advocate for unchecked piracy, but emphasize the need to explore alternative models that respect both intellectual property and equitable access to information. The ethical dilemma surrounding intellectual property piracy should be addressed through market-driven solutions and international cooperation. Evidence demonstrates that excessive copyright enforcement can harm innovation, limit knowledge sharing, and exacerbate economic disparities. Let us consider innovative and evidence-based solutions to address this ethical dilemma while preserving individual rights and fostering creativity. And now we invite the government whip, Casey Arante.
Thank you, Speaker. In conclusion, ladies and gentlemen, we must recognize the ethical dilemma surrounding intellectual property piracy. It's not a simple issue with a one-size-fits-it-all solution. The opening government's proposal does not advocate for excessive government control, but seeks to initiate a comprehensive dialogue that strikes a balance between protecting creators and ensuring the public access to knowledge. The government should be proactive in facilitating international discussions to find equitable solutions. We urge you to support this motion. Instead of solely relying on copyright enforcement, we should explore alternative models such as open source software that promote both innovation and equitable access. Evidence-based solution can help us address this ethical dilemma without stifling information sharing or disadvantage the economically vulnerable. I would like to emphasize that our ethical dilemma involves striking a balance, and it also requires us to address economic disparities while protecting intellectual property. Evidence shows that strong intellectual property rights can coexist with equitable access. Governments worldwide have been pursuing policies that balance both interests, fostering creativity and protecting the economic interests of creators and companies. Evidence-based strategies like targeted enforcement against large-scale pirates can help us achieve this balance. And we must find ways to protect the rights of our creators and innovators while ensuring that the benefits of knowledge and culture are available to all. It is through responsible governance and international collaboration that we can navigate this ethical dilemma, and we should explore alternatives that prioritize equitable access to knowledge while addressing the economic disparities. Evidence-based studies show that open-source software and affordable content distribution models can thrive without resorting to piracy. In conclusion, our government's position remains grounded in evidence and the ethical imperatives to protect intellectual property rights. And we are open to exploring new solutions and technologies, but we must ensure that these alternatives are legal and do not undermine the creators who invest their time and resources in producing quality content. The ethical dilemma of balancing access to information and innovation requires a nuanced approach guided by research and ethical principles. We urge all members to consider the evidence and stand in support of intellectual property protection.
Thank you to the government whip for that speech. Ladies and gentlemen, what an engaging exchange of ideas we've witnessed today on the topic of intellectual property piracy. Our debaters have demonstrated intellect, passion, and the art of persuasive evidence-based discourse. Before we conclude, let's express our gratitude to the participants for their insightful contributions. A round of applause, please.
In the spirit of healthy debate, let's remember that it's through such conversations that we expand our understanding and enrich our perspectives. Regardless of the outcome, each debater has played a crucial role in advancing the discourse on this important matter. Thank you to our audience for your attentive presence. We hope this debate has sparked thoughts and inspired further exploration of the topic. As we part ways, let's carry the lessons of today's discussion into our own conversations and continue to engage in meaningful dialogue. Thank you all for being part of this enlightening event. Until next time, stay curious and keep the conversation alive.